Okay, it might be a good segue now into Sullivan.
Sure.
And Sidney Powell's. Oh my goodness. Okay, so we going back. I'm not summarizing the Sullivan situation, the Michael Flynn situation. Everybody knows it. The most recent thing that happened, we had the hearing in front of Sullivan, 5 hours of eye-scratching pain. During the hearing, we talked about it briefly during our stream. So I didn't really appreciate how over the top it was until reading Sidney Powell's motion to recuse and for other relief. Sidney Powell filed a motion to recuse. She says Sullivan has to recuse himself. He's given the appearance of partiality. A reasonable observer would fear the bias in the system, et cetera, et cetera. He's got to recuse himself after he grants the motion to dismiss. But in her scathing, I mean, it's so bad in terms of what is alleged in it, but it's all fact. She alleged that to evidence Sullivan's bias, he considered evidence and included it in the docket. I presume that's what it means, is when it's filed in the docket, it becomes an exhibit in the court file. A letter that he received directly from Stroke's attorneys the night before the hearing, not communicated to the other parties, that he addressed as evidence during the hearing. Now, this is the first element that we have to talk about. You voiced your concern on that. I mean, explain to people how over the top that is.
Yeah. So, I mean, to give you, like, if I had been, the only area where I would disagree with how Powell went about it is that given the timing of this motion to recuse and disqualify, and given the Court of Appeals statements already, I would have not brought up all the old stuff. I get why she's doing so, but she's already got that in the record. So what I would have done is make it all shocking new evidence that the judge has been subject to ex parte illicit communications. And I would say, because I think she now has a good faith basis to say it, and she goes almost there, to say that it appears that Judge Sullivan is part of a conspiracy with outside actors connected to the Obama administration to continue to railroad General Flynn and to cover up the corruption of the Obama administration, and is using private counsel and ex parte communications to facilitate it. She hints at this, but I would just make that the whole motion. I wouldn't bring up all the old stuff. Let it be. Instead, start there right away, because she's clearly got inferential evidence of that. Why did these lawyers have so much confidence that were representing Peter Stroke or representing Andrew McCabe, that they could just email a judge a letter and know that he would even read it? You're not supposed to be a judge. You're not supposed to be reading anything sent in ex parte to you in a case, for obvious reasons. I mean, if judges could do that, there's a lot of letters I'd love to send. I mean, you're not, as a lawyer, you sure as heck aren't supposed to do it. And as a judge, you're not supposed to do it. I think it's one of the people that you wanted to thank for Thanksgiving, or not thank for not being that lawyer who misunderstood the rule, right? I've had a lawyer do that to me before too. I didn't realize Thanksgiving. Happy Thanksgiving. I guess it's like happy Thanksgiving for Canada.
Happy Thanksgiving in lockdown. I had a lawyer. Write me an email, CC his client, and when I inadvertently replied all just because you do it, he then says, you corresponded with my client without my permission. I'm going to threaten an ethical complaint, which itself is an ethical violation. I contacted the bar. They said, look, it's a gray zone. Obviously, the intent matters, but just be careful.
And imagine, and here you have a lawyer communicating ex parte to a judge, emailing him letters, and rather than the judge saying, "Oh, that's horrible. Stop that. Don't ever do it," he's like, "Thank you." And uses it, sticks it as evidence into the record unilaterally without it going through any proper evidentiary protocols or procedures, and then calls it disturbing and unsettling and a whole bunch of other nonsense because they lied about, they kind of misread what the letter was. What really happened is both U.S. attorneys, when they produce discovery, they often put sticky notes on items. And when they copy it, they often copy it with the sticky notes attached to let you, the defense lawyer, know this was the date of this or this was the information of this. Well, McCabe and Stroke's lawyers wrote in and say, well, we didn't write down that date. Well, frankly, Judge Sullivan, if he was competent, this is what happens when you're really dumb. But if you're competent, would know that was the case. And he tried to make it sound like maybe the government was doctoring evidence and doctoring testimony to help General Flynn.
It's mainly someone on Twitter alluded as much in the question, said, well, judge points out altered documents, they flip, Michael Flynn's attorneys flip out. So And then you clarified this to me, but so that's it. It was either whether or not you accept this explanation, even if it were adding a note, it's a non-material addition, but they photocopy.
It's commonplace. The reason for folks out there, what's happening is a prosecutor's reviewing a bunch of evidence. They know what date something was pulled, but often that date is not on the document. So in order to help me, the defense lawyer, they put a sticky note on it, write down the date, and when they copy it, digitize it, and send it to me, that will have that date on it. And usually I know that is not the original signature, and it's completely immaterial for the purposes of the internal notes. It's solely for me as a defense lawyer to know when this was done. So for those lawyers to write in and say, oh, we didn't write those dates when those dates were accurate anyway, was really a misleading set of information. They could only get away with it because it's not sworn evidence. They're not licensed to appear in the case, and their client's not a party to the case.
People need to appreciate that. Well, first of all, it might even be worse if it's a lawyer in the file corresponding with a judge without notifying the other party, without including the other party. This is someone who's not a party to the suit, not represented in the suit, who has not made any motion to intervene in the suit, writing the judge and saying, look at this. Here's a letter. Here's some evidence. The night before a hearing, apparently it was late at night. I think it was 10 o'clock, and I don't remember why I know why I remember that, but I may be wrong. The day before the hearing anyhow. And the judge invokes it during the hearing. So, and going back to one thing, what you said, Sidney Powell bringing up the things that the judge said, treason and this and that back in 2018. When I did my video, I said, she's rehashing these arguments. Court of Appeal already discussed it. Bringing it up almost, I didn't say it in this detail, but it almost weakens the better arguments.
Correct.
And then you get to the new stuff. And I think I alluded as much where I got the impression in reading Sidney Powell's motion that she knows something that she's not specifically saying right now.
And I would have started right out because it would have led the news if she would have done this, not the institutional news, but at least the conservative news, the pro-Flynn news, was there is evidence now of what we have been, or at least I have been hinting at. I don't necessarily impute it to you unless you ever run into Judge Sullivan, which is that Judge Sullivan is acting at the behest and behalf of Obama. And that he referred to Eric Holder. He made a miscue during the hearing. He referred to Eric Holder by his first name, Eric, which was what happens when you're dumb, people. When you're dumb, it's hard to also be corrupt because you spill it out. And so the second thing is, apparently his personal lawyer is staying at, which I thought never should happen in the case. The judge should have written his own opposition to the mandamus. He shouldn't be allowed to hire third-party counsel because that creates a whole nightmare set of problems. Would you
mind refreshing the memory of the crowd of over 10,000 people now? Who is Sullivan's private attorney?
So Sullivan's private attorney is one of the key Clinton email people. So she was representing Cheryl Mills. I think is currently representing Cheryl Mills. Yep. By the way, how is all that not a conflict? How do you end up, if I end up trying to represent like everybody involved in Build the Wall, I guarantee the government would move to disqualify me right away by saying there was a conflict between the people involved. How is it that this lawyer is representing almost all the people that were the underlings in the Clinton, all of whom had criminal exposure because of their deletion and destruction of documents after they were, by the way, under subpoena? Unlike what happened with McCloskey, which we'll get to later, there was a clean obstruction charge against every one of them. And she goes through representing one, gets a sweetheart deal, then represents another, gets a sweetheart deal. And now she's representing the third, Cheryl Mills, the lawyer, who was integral to all of this. So somehow that's who Sullivan decides to hire. And the problem with that is, one, that shouldn't happen, period, because this is the risk it creates. You have a judge communicating ex parte with people who are not part of the case about the case. And he can do so under the guise of attorney-client privilege communication. And he's doing it with someone who is connected to all of the Clinton people and connected to all of the Obama people.
And just so nobody is thinking now, Robert, you are just bringing up the Clintons and Obamas. Sidney, in her motion, brings up why this is all relevant in that the newly disclosed evidence suggests that it was actually Hillary and her people, the very aides that the lawyer to the judge is representing, who concocted the framing of the Russia idea in the first place to use ostensibly to get Flynn. So I'd say it's a small world in general, but this is there's an incestuous world in general in the legal community. But there is next level incestuous legal relationships. And this is if you want to talk about creating an appearance of bias in a reasonable person, there's no one on earth who is not fully partisan to the core. And even they, I think, would recognize it, that would look at this and say it doesn't reek of something improper.
In my view, it smells of criminal conspiracy. I mean, I think there's enough. You have a federal judge communicating with the people who work to frame and set up General Flynn, trying to keep that frame and set up alive. And you have him communicating with them outside of court proceedings. And it appears coordinating strategy with them. I mean, that's the Powell doesn't go and say that explicitly, but that's the inferences of what she's saying. I would have said it. It would have been my first paragraph. It looks like we have a case of a substantial federal judicial corruption, and that there needs to be an investigation. And she did ask for all of the judge's records. I would have asked for even more. I would have asked for the judge's social, because the judge is now admitting he's reading things on social media that relate to the case that are not introduced in the proceedings. He's reading outside news stories about the case that are not part of the proceedings. He's reading outside emails from lawyers trying to introduce documents that are not part of the proceedings. This is extraordinary. Not only is it all extremely unethical, it smacks of a criminal conspiracy against General Flynn, which is being orchestrated by Judge Sullivan on behalf of the Obama and Clinton allies.
I make the joke in my own head. I'll make it out loud. It's almost as though the prosecuting side is guilty of the very things that they are accusing the Department of Justice and Michael Flynn of doing. Almost pure projection of the purest form. Okay, so I mean, I think people have to appreciate that aspect is over the top. The relationship between Sullivan's attorneys, whom apparently he's still, your camera is now still wobbling. Apparently, Sullivan is still in corresponding with Wilkinson, and I don't know why they'd be doing that at this point, since Sullivan's motion in the mandamus part is done and over with now.
Correct. I mean, that was always lame and ridiculous that he had his own counsel for that. That never made sense to me. But that should have been that he had nothing, that he should have never communicated with her. She should have done her own independent legal briefing, independent work, even if you were going to allow that to happen, which they never should have allowed to happen. But now it appears that, in fact, this was part of a coordinated effort, that they're coordinating strategy. Remember, he went out of his way to say how he and Gleason hadn't personally met outside afterwards. But as Powell makes note, he didn't say whether or not his lawyer had been meeting with Gleason.
I know, these are the statements that drive me nuts, because they may be true, but anybody with a remotely legally trained mind knows exactly that the lie doesn't come in the truthfulness of the statement, but rather in the omission of what all else is not being said, ostensibly under the guise that everything else follows that is true from this small statement. I never met with Gleason. Good. I mean, what on earth does that mean? You have legal representatives. That's what you have them for. And do I believe? I love how she says, like, Sullivan took Gleason's op-ed like a job application. I mean, it's old stuff that has been rehashed, but if they're not talking, they're mind reading, and there's no such thing as mind reading type thing. Actually, here, I want to bring this up here. Angela B says, a couple of weeks back, you said Flynn couldn't sue the government. Why then would the investors run out and buy liability insurance? I don't know if I ever asked you this question. The idea that the employees would have to buy liability insurance, when I read that, I took it not as an actual admission that they saw exposure, because I would have taken for granted that they're covered by some sort of employee coverage or employee insurance or immunity to begin with, and that it was just sort of a tongue-in-cheek joke which illustrated guilty intent and not an actual sentiment of exposure. Am I wrong in that reading?
No, I agree. And I'm still not sure if that story is correct. I never saw confirmation that they actually obtained independent liability in coverage, because, yes, they're either anything they do in their governmental capacity, they're immune from. And if they're not immune under the Federal Torts Claim Act, then the government's on the hook for, not them, effectively. Is the way that works. So now, if they did things outside of their government capacity, so there might have been risk for some of them that they were doing things outside of when they were not inside their government duties, they were doing things that might have been illicit as well. So that would, like, you had Nellie Orr, the wife of the department, working with a private committee, getting paid by a private organization to help coordinate the Russiagate activities. So there may have been worries that they could be accused of conspiring as a private participant and unclothed in governmental immunity. That'd be the only reason I can imagine that they would actually look into getting liability insurance.
Yeah, because I mean, so another good point is the statement was that they were going to go out and get liability insurance. No evidence that they actually did, which would probably be invalid. It would be invalid insurance anyhow if you get it to cover the risk of an incident that you know exists and that already occurred. Is one thing, but when I read it,
supplemental coverage at the most.
Well, and so I mean, there's that. But when I read that comment, I didn't read it as a serious, holy crap, we're in trouble, let's go get insurance. I just read it as like, as a tongue-in-cheek joke that, you know, translates badly via text. It's like, my goodness, with what we're doing, we better go get liability insurance, as more of an admission that they know what they're doing is sketchy, not that they need to get insurance to cover their butts for the sketchiness, which wouldn't work anyhow. Right. Okay, so what else was there? So Sidney Powell has asked for, I mean, what are the chances she gets this? She asked for correspondence between.
Oh, you mean the info? I thought you were asking the chance she gets recused.
No, forget the recusal. We agree, recusal, 0% chance she's getting it.
Yes.
But what are the chances she gets any of this information that she's requesting?
That's going to be interesting, because now here's what I would have done if I'd been in her shoes. I would have put in a prof. I think she really wanted to go at Sullivan, but there was a part of her that didn't want to go to the conclusion that she was inferring for everybody. I would have, because you almost have to. Because if you want to get that information, you have to do what's called a proffer, an offer of proof. And I do this all the time, because one way judges screw you in cases is they'll deny you some evidence you want to get into, or some cross-examination line you want to get into. And a lot of lawyers make the mistake of not doing an offer of proof at that point. And so then when you go up on appeal, you can't get it reversed, because you can't prove what you would have been able to prove had the judge allowed you to go into that area. So I always do, well, judge, I got to do an offer of proof. It always makes them mad because of how rare it happens. And they know of its appellate significance. They're so used to getting away with it. And they really get annoyed when I get to lay out what my offer of proof was. I tell people, do the best possible version of events that would have happened for you. So in this context, I would do an offer of proof. And I would have said, my offer of proof is that with this evidence, I'll be able to prove that Judge Sullivan is part of a criminal conspiracy to cover up for the people who helped frame General Flynn. And here's what this evidence would show. You do the best possible version of what that evidence would show. Because if you don't, then he can deny you access to that evidence, and you lose your appellate argument as to what that evidence could have proven, because you did not produce an offer of proof. She needs to do an offer of proof at some point. I
take for granted in the States that if you can appeal the refusal to admit evidence of right.
Mm-hmm. Well, I mean, it's all after the trial or after the hearing. So but it's a separate issue. In other words, and what it really does is it says, if I had these set of facts, could I have got recusal? And if the answer is yes, then the fact that I was denied evidence that could have proven those facts becomes reversible error. Also, it's a great way to put in your best version of facts. So the judges go AWOL when they see it. They're like, you can't prove that. It's like, I just want the evidence. I think I could prove it with the evidence. Maybe I can. That's why I need the evidence.
And what I love is that this is consistent with the, your strategy from the beginning to flip the entire argument that Sullivan just wants to inquire as to the executive. Well, now the executive just wants to inquire as to the judiciary's MO and pattern and decision-making process in going after all of this. So she definitely does not get the recusal. Does that decision, does he adjudicate on the Department of Justice's motion to dismiss prior to the recusal, or is he going to say, I can't decide on the DOJ's motion to dismiss until we decide my recusal, which I'm not granting. If you want to go appeal it, see you next. It won't even be next Christmas. See you next summer.
And if he wants to buy more time, he'll ask for more briefing on the recusal issue.
Yeah. Pink Sniper says, how confident am I in my bet with Uncivil? I'm going to be shamefully senile right now. I forget what bet I made with I forget what the bet was.
It was during the hearing. I think you bet a bottle of whiskey.
Yes, we bet a bottle of whiskey. What position did I take? Whatever. I'm doubling down on my position. I'm gonna have to go back and I'll have to ask Uncivil what my position was, but it was a good bet. Kurt's gonna get me. I'm winning. Okay, so let's see. That covers Sullivan. Was there any other really big issues that she raised in the motion to recuse? No, I think
she did detail that new evidence that you were talking about. That this all was about the Clintons started the whole thing. The Clinton campaign said, now Obama always wanted to get back at Flynn in particular, but that the Clintons started in order to cover up for their email scandal, started the whole Trump-Russia thing. They put that whole. Not only did they launder the money through their lawyers who paid Fusion GPS, but they were the ones. It was one of their aides that came up with it, and that information Brennan knew, told Obama that information, and they had tried to sit on it for the last 4 years.
What do you think? I mean, I don't remember if we talked about this. What do you think of her request to Trump not to pardon Flynn?
I understand the logic of that. So just to delay and postpone it and see what justice she could get out of the proceedings. Now, when she told him that, she was very naive about Judge Sullivan. So she thought Judge Sullivan would be great on discovery and has been totally shocked. And probably the only part, I mean, I understand where it's coming from, but there was a tenor to the brief that which is a natural temptation, which was personal. And I understand why she was being personal. I mean, I think she feels personally betrayed by Sullivan and is shocked by that. I have such low confidence in most federal judges that, they can't disappoint. They can only surprisingly be better than expected. And I say that as someone who, has friends that are federal judges, that there's some that are great, but there are many that are not. I would have tried to take a different approach. Now that comes from years of battling it out. Your natural instinct is always when someone's coming at you personally, coming at you professionally, your natural instinct is to defend it. And if you're one of those idealists, and there's a part of Sidney Powell that's an idealist, wants to believe in the system, then you really feel personally betrayed. And that tends to come out in your writing, which is understandable. It's just, I think it's more persuasive if you just step back from this and say, oh my goodness, I'm shocked to discover this scandal. And you can make your personal points, but do so in a way that's I think a little more effective, but at least been more effective for me. Everybody's got their own style, but you have to be through these wars to know how to deal with them. It's very hard dealing with dumb, corrupt judges.
No, and it's the prime reason why I said in one of my older vlogs that even lawyers, if they think they can represent themselves, should get a lawyer to represent them because you need the distance from your own emotions to the file. And Peppermint says, can you discuss the fact that this is about one count of falsifying evidence? Wasn't the penalty probation? So this is another thing. In Canada, at least, a day at our superior court costs $10,000 in administrative fees, salaries, judges' salaries, rent, whatever. This is you can't put a price tag on this. I was trying to think of how much it could have cost. These hearings, Wilkinson, being paid on taxpayer dollars, Sullivan's salary, the prosecutors, Gleason. Who's paying Gleason? Who is paying Gleason for all of this?
And
who does he invoice?
I'm sure he's getting paid by the court. I mean, that's why these court-appointed amici for the district court level, it's just in criminal cases, never seen it. And they really didn't deal with that at the Court of Appeals. They had an excuse as to why, there's amici all the time. Well, you notice they didn't talk about the Federal Rules of Criminal Procedure, which Powell went into great detail on. They completely just decided that those rules don't exist. That's how they lie in court records, by the way. They lie by omission of what's in the. This was like part of the issue with the Barrett cases, where people saying, here's what she means. It's like the courts lie all the time in what decisions they issue. They don't accurately describe the issues. They don't accurately describe the facts. When they're out to screw you, they make it sound like, obviously this is the conclusion from these set of facts and this law. Yeah, of course. If you lie about the facts and lie about the law, you can get people to draw to any conclusion. So never trust a court's version of the facts and the law, folks. Read the record.
I think I've just blown my own mind with the revelation that Amicus Gleason literally is he's literally invoicing the court for his time.
Yes, exactly.
Along
with his private counsel, along with the 4 law clerks Sullivan as a federal judge has 4 highly paid law clerks that work for him. So they're the ones who are, shaping ideas and the rest. But the really shocking part is, while I believed it was happening, I didn't believe you'd ever get proof that Sullivan was really coordinating on behalf of, I think, more the Obama people personally than the Clinton people. But they're deeply overlapped in this because they both were doing the same corrupt activities on behalf of one another and each other. Their goal and their objective, it wasn't a coincidence, folks, that the same people involved in Clinton email investigation, same people involved in the Clinton Foundation investigation were the ones running Spygate. Okay, that wasn't pure chance. That wasn't circumstance. But it's extraordinary is really Powell's got evidence of it, that he's using his private counsel to launder information and legal strategy, and he's receiving ex parte information. Like, how did he know about the letter Sidney Powell wrote? It's like he claimed it wasn't in the record. Now, he was wrong about that. There was references to it all the way early on, but he didn't. What it was is he didn't get it from the record. He got it from somebody else. And I guarantee you, as dumb as Sullivan is, he didn't come up with the political strategy to use that. Someone planted that in his head. And so he thought, oh, this is going to be great. This is what dumb people do. They think something's great that's not great at all. That's the only problem for the system, is they have a judge happily willing to be corrupt for them, but he's too dumb in the way he administers things, and he's going to spill the beans sooner or later. And I hope at least Barr continues to punish him by leaking out discovery through Sidney Powell, because it's not happening in the Durham case.
And by the way, Pink Sniper is, I remember my bet now. Yes, that Sullivan is going to grant the Department of Justice's motion to dismiss. Kurt and I are going to have to discuss the possibility that Flynn gets pardoned, and then we never have a resolution to this debate, to this prediction. But no, I still think Sullivan's going to grant it. But I think this has just added indefinite amounts of time, but definite amounts of time, because Flynn is going to get pardoned before Trump either leaves office if he doesn't get elected, or if he does get elected, it'll go into next year. It'll be an interesting thing to see.